Good afternoon, everyone. I will call this special meeting of the Community Oversight Board to order. It is 1:30 on October 23rd. I'll start with the reading of the appeal statement. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of cert. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. I will go ahead and do a roll call here. Second. Mr. Campbell-Gooch.
Here.
Ms. Davis. I know she said she might be a little late. Mr. Goddard.
Here. Sorry, here.
Dr. Hildreth.
Present.
Mr. Holloway.
Here.
Mr. Hughes. Is Mr. Hughes on? Okay. Ms. Lewis, Dr. Lewis. Also not here. Ms. Ross.
Present.
Mr. Sweeney.
Here.
And Mr. Witzel.
Here.
All right. I will move it over to Mr. Pinkley for the electronic meeting statement.
Thank you. So on March 20th, 2020, Governor Lee issued Executive Order 16, suspending the in-person quorum requirements for meetings. That has since been extended through Executive Orders 34 and 51, and most recently with Executive Order 60, which is set to expire next week on October 28th. So in order to conduct today's meeting, we just need a motion and a second to conduct essential business and doing so electronically to protect the safety and welfare of Tennesseans.
Thank you, Mr. Pinkley. Is there a motion?
So moved.
I think that was Mr. Sweeney with first.
Mr. Witzel.
Okay, is there a second then?
Second.
All right. Any discussion on that? Not. Go through a roll call vote here. Mr. Campbell-Gooch.
Aye.
Ms. Davis. I don't think she's here yet. Mr. Goddard.
Aye.
Dr. Hildreth.
Aye.
Mr. Holloway.
Aye.
Mr. Hughes.
Aye.
Dr. Lewis. Ms. Ross.
Aye.
Mr. Sweeney.
Aye.
And Mr. Witzel.
Aye.
Thank you. The motion passes. All right, so today we're going to get right into it. Today's special meeting is to review the COB's first ever proposed resolution report. For those of you listening at home, and as a refresher for board members, the proposed resolution report is the result of an investigation by MNCO staff of an allegation of misconduct committed by an officer. This report was prepared by the executive director, and it represents the totality of the investigation conducted, the evidence collected, and the conclusions reached by MNCO investigators. Our bylaws make it clear that we must approach this report with the presumption of correctness. That means we presume evidence contained in this report is correct as written, that all evidence in this report was properly collected by our investigators, and that the evidence was properly reviewed and analyzed by the executive director. The executive director has reached her conclusion based on the preponderance of the evidence. Our job here today is to be impartial reviewers of the conclusions reached in this report based on that evidence. The complainant and the accused officer have also received this report. They've been given ample time to request to speak at this board meeting, but neither has made a request to do so. The evidence has also been made available to board members should you all have had any questions or wanted to review the evidence yourselves. But I'll again remind you that today we're not having a discussion on investigation tactics or the validity of the evidence. We're having a discussion on the conclusions reached by the executive director based on the evidence in this report, which we presume to be correct. I will shortly hand it over to Director Fletcher to present her findings in this case. And after Director Fletcher has presented her findings, I will ask for a motion to approve the proposed resolution report as submitted and properly seconded. Then I will open the floor for discussion for any board member comments or concerns. As we discuss the conclusions of the report, the board can vote on the following options: to accept the report as submitted, to accept the report but with edits, to reject and request a revision that reaches a different conclusion, or to return for further investigation or analysis. If the report is accepted as submitted, the report and its recommendation will be sent to the Chief of MNPD for consideration, along with the entire investigative file. As of today, we're still operating under the original MOU, which states that the Chief will review the report and provide a written response within a reasonable amount of time. And with that, I will hand it over to Director Fletcher to present the proposed resolution report.
Thank you. Good afternoon, board members. I'm presenting the proposed resolution report for MNCO case number CC 2020-016. As Chair Martinez stated a moment ago, you should have received a copy of the report that was provided to you originally on October the 9th, 2020. The PRR was also uploaded to the COB website for public viewing, and as well as each party involved was notified according to the COB rules, and they have not requested to speak today. So I will summarize this report and go over the key issues. And so let's begin. Section 1, allegations of misconduct. Allegation 1, courtesy. Allegation 2, failure to provide assistance. Section 2, summary of complaint allegations. The complainant filed a complaint with the Metro Nashville Community Oversight Board on May 5th, 2020, and alleges that on May 1st, 2020, an MNPD officer was rude, continually cut her off when she was speaking, and refused to take her statement to add to a traffic accident report. Specifically, the complainant stated that she was involved in a traffic accident that occurred at Harding Place at I-24 West on April 27, 2020. She stated that officer did not include her statement in the traffic accident report because she was transported to the hospital for an evaluation. On May 1st, 2020, complainant spoke with officer by phone and asked him to take her statement and add it to the traffic accident report that he completed. The complainant alleges officer stated, "No, I don't need your statement. This is civil. I don't need to talk to you, and that this is what it is. I will change nothing about it." Section 3, policy violation. The possible violation to MNPD's manual is section 4.20.040, personal behavior, section G, courtesy, category F. Section 8, conclusion. The evidence contained in the file was carefully reviewed, and based on a preponderance of evidence, this is my conclusion and the recommended action. Allegation 1, courtesy. I conclude that although the complainant stated the officer was rude and cut her off continually when she was speaking, the officer stated that he was professional in manner when speaking with the complainant, and since there was no supporting evidence by either party, the allegation is not sustained. Allegation 2, failure to provide assistance. I conclude that since there is no policy requiring officer to take the report, this allegation cannot be sustained. Therefore, the officer is exonerated by policy. As a result of this policy exoneration, the COB will request that MNPD adopt policy changes listed in the recommended action section of this report. The COB believes that these policy changes will improve the services offered to the community by MMPD. Section 9, recommended action. To enhance procedural justice in similar instances in the future, the COB recommends that the MMPD Department Manual should be amended to state that when vehicle occupants involved in a collision are unable to give a statement because of medical transport and subsequently desire to give a statement, officers should add their statement to a supplemental report. This concludes the reading and recommendations of the proposed resolution report, case number CC 2020-016.
Thank you, Director Fletcher. Now I would ask for a motion to approve the report so we could discuss it if the board needs or has any comments or would like to discuss it further. Mr. Kempich.
So just a real quick question so I understand the process. So we would have to have a motion to approve before we can discuss.
Correct.
Is that right?
Yes.
I'll make a motion to approve the report.
Thank you, Ms. Ross. Is there a second?
Mr. Drew, I'll second.
Thank you, Mr. Goddard. Any focused discussion then?
Yes, it's Officer Holloway. Can I make a statement?
Yes, Mr. Holloway, go ahead.
Based on my experience, that officer should have taken a report due to the fact that the lady was transported to the hospital and she requested her statement be included to the report. And the simple fact is, it's easier to do a report than to be bogged up in a lawsuit. She could sue him and the department. So it's so easy to do a report to eliminate that process. I've been in a situation before, and normally a supervisor will give you an order to go and take a report. But in my situation, I knew that me being involved in that situation, it would be better for me to go ahead and do the report than to have to go through my supervisor and get written up for it. Because had I not followed up on that report, they would have been more than likely would have written me up, for not completing the investigation. When you're on an accident like that, and the person got to be transported, if he's there and she's there, he can give that information report, his name and the complaint number of the report for a later date when she is in stable condition to give her a version of it. But if she's not there, then he should go to the hospital where she's located and see if she's able to give a report. Then if not, then leave that information form there at the hospital with her personal items and let the nursing know that this is the information report and this is what she would need if she cared to further. So it save a whole lot of lawsuits, and that if you go ahead and just knock out a report, what they said, be done with it, even though it's civilly determined in the court who's at fault. So let the insurance, let them fight over it. Don't let that be on your back and put your job on the line.
Thank you, Mr. Holloway. Mr. Sweeney.
I'd like to talk generally about the process, but I'll wait until we're done having specific comments on this particular report. So I'll just defer for the moment.
Thank you, Mr. Sweeney. And Mr. Goddard?
Yes, I want to follow up on Member Holloway's comments. His, I think, go to whether an officer should at the scene, take the statements. I agree with everything he said. It seems to me another distinction, and I'm addressing the last paragraph, the enhanced procedural justice, not the specific actions of this officer. I don't know enough about that. But it seems to me an officer either should leave it to the insurance company and not find fault. And if he can take whatever witness statements he can or whatever the other policies say about which witnesses should get statements, that's fine. But if an officer decides to make a fault determination as opposed to just quoting witnesses, then he should make every effort to get a statement from the party he is finding at fault, he or she is finding at fault, regardless of why he didn't get the statement first time around, whether they're gone to the hospital, something else happened, whatever. If he or she is going to find fault, they should offer every opportunity for that witness to make a statement. And certainly if the witness calls in and wants to make a statement, should amend the report. Those are my thoughts.
Are you phrasing that as a recommendation, or are you saying that is the policy?
I am suggesting that concept as a recommendation. I would like to hear from others, and that was too rambling to be a specific set of words. I'll try to do better if others agree and we come back to that.
Thank you for clarifying that, Mr. Goddard. Mr. Sweeney, I still see your hand up, but I think you just haven't put it down.
Correct.
So we have a recommendation to approve that the MNPD's policy be changed to be able to accept someone's statement if they are transported to the hospital. And we have what I think is Mr. Goddard's recommendation, maybe strengthening that. Is that where we are? Dr. Hildreth, I see your hand up.
Thank you, Chair. As a part of general discussion, I would like to invite our community nominated and appointed board members to say more. I'm interested in hearing what the community response is at this point. Thank you.
Thank you, Dr. Hildreth. Mr. Hughes.
Yes, thank you, Chair. I did have a question specifically about the second element of the allegation related to failure to provide assistance. Can I get a little bit of clarity about what the current MNPD policy is regarding that specific issue? And then I give another comment.
Okay, I was having a little trouble hearing you, but I think you asked for what policy currently exists for MNPD. Is that correct?
That is correct, specifically as it relates to the second allegation of failure to provide assistance.
Director Fletcher, can you tell us more about that?
Yes. So for this traffic accident, hold on, let me pull it up. All right, so there isn't a specific policy regarding the failure to provide assistance. And so as I was reviewing the policy that pertains to this specific incident, which is MNPD policy 18.20.030, which is, I included it in the evidence, it's in our file. It has specifics in regards to traffic accident reports in the documentation. And so there wasn't a specific policy that talked about the, if a person is injured in an accident, how to get their statement from them. And so even in the documentation portion, it didn't really have any language that talked about, you know, making every effort to get that information from a person if after they've already been, you know, once they've been transported to the hospital. And so I think that is why I came up with that is the reason why I came up with the recommendation that if a person is transported from the scene for medical evaluation or whatever type of injury, that if they decide to come back and have their information provided in a supplemental report, that should be policy opposed to discretion. And so that's all I have to say about that, because there's no policy regarding assistance, the failure to provide assistance.
That's very helpful, Director Fletcher. Thank you very much. I think maybe the issue that I had, or the question that I had, centered specifically around what the current policy is. And it is helpful to understand that there at present was not a policy that specifically required MMPD to take that report or to offer assistance with providing that report. And so I think for the members of the community, specifically those who might be in a similar situation where they find themselves either in a traffic accident or in the aftermath of a traffic accident being transported for medical reasons, if at some point in the future there is a concern over an issue related to something that needs to be reported or to have a record made of information in exchange in the aftermath of an accident, it is certainly helpful for community members to know what policies and procedures currently exist and how those procedures can be enhanced by such a proposal as we are now considering today. So thank you very much for that clarification.
Thank you.
Thank you, Mr. Hughes. Ms. Ross?
Yes, I also agree with the resolution report that there be a change in the Metro Police Department's manual, adding a supplemental report for individuals who are injured at the scene of an accident. And unfortunately, in this day and time, I'm surprised that it's not included in their manual where people can give a report once they're well enough.
Thank you, Ms. Ross. Ms. Davis.
Yes, good afternoon, everyone. Yeah, I agree wholeheartedly with everything that's been shared, including Mr. Goddard here. And what he shared, just I want to support that if, you know, if our officers have the and I would say it's a privilege and the authority to make statements, whether it's, you know, forthrightly or not, to assert, you know, let's just say outrightly that, you know, one person is at fault or not, then they should have the responsibility to get the statement of everyone involved. So at the very least, get everyone involved in an accident. And if that person is, to Ms. Ross's point, is not available because they were injured or not at the scene because they needed to get medical assistance, then we get that person interviewed later. It also begs the question to me, you know, and we didn't talk about, you know, demographics of the person or, you know, some socioeconomic or race or any other thing. But without going into that, it just concerns me what the strains here of whether or not this person was not listened to or their voice was not heard because of one of those indicators there. And so as MMPD looks to strengthen their relationship with the community, I would think that they would want to listen more than they have in the past. And this is a great opportunity for them to revise their policy to do just that, whether it's on the books or not. And I just want to say just very quickly, something that came out on October 14th in a meeting with the mayor, and I'll talk more about this next week, was the mayor asked the policy committee to point out any inconsistencies in current MMPD policies where the police are saying they want to do a better job of working with the public, but it's not currently in black and white in their policies. So this is a perfect example of that. And so I just would encourage MMPD to do just that. And I think this is a great example of that.
Thank you, Ms. Davis. Mr. Calhoun.
Yeah, so I have a question first that I think is like maybe a remedial question, but I just wanted to just gain a compass, especially factoring what Holloway kind of explained earlier from his experience. So did the officers say what stopped him from taking the person's statement?
If you read it, you'll see.
My understanding is that since there is no policy requiring him to do so, he didn't take the statement.
Right. Yeah. So I was just trying to make sure I was clear on that. So
yes,
I think it is. I think the words that's coming to my head seems disturbing, but I mean I don't want to use that word, but I think it's like very interesting, and it feels like we're gonna have to create policies to make folks more humane. I mean, I guess I don't see why taking the policy down, and this is just from a community standpoint, I don't see why taking someone's policy down would be a stretch. And I don't understand why like that basic idea would need to be cloaked in policy just to ensure that folks are treated with dignity. And so I just wanted to, just in response to what Dr. Hildreth mentioned. So yeah, I just wanted to put that here.
Thank you, Mr. Campbell-Gooch. Is there any more discussion on this? Going back to your recommendation, Mr. Goddard, are you wanting to amend the executive director's recommendation here?
I would suggest language that says, and I'm making it as I go along, if in a report an officer finds fault, the officer shall permit the party found to be at fault the opportunity to provide a witness statement, and in other cases may or is encouraged, whichever the group wants, but let's say may do so. And that's off. That sounds like a lot of legalese. If somebody's got a better way to de-lawyer that, I'm open to that too.
Thank you, Mr. Goddard. Director Fletcher.
I understand what Mr. Goddard is saying, but I don't want us to forget that we need to also have language in there that incorporates if someone is transported to the hospital, because I don't really think the policy states that officers should be finding fault. So I think that if we're going to use that language, that if they're gonna, whatever Mr. Goddard just said, we need to also.
I'm sorry, mine was in addition to that, not in lieu of that. Okay. Sorry, I did not make that clear.
Okay, gotcha. All right, that's all I wanted to say. So thanks.
Can I add in one other thing?
Yes, Mr. Sweeney.
From my experience as a judge in cases where officers have been involved in investigations, there is a regular part of the report where they have the opportunity to assign fault. On the other hand, the reports are not admissible in evidence by statute. So they can't actually be offered in testimony in a civil case. I don't think they can be offered in a criminal case, but I don't know that. But I can tell you from a civil standpoint, it can't be offered in evidence, just for whatever bearing that has on our overall consideration.
Thank you, Mr. Sweeney. Mr. Goddard.
Yes, Mr. Sweeney, my concern is not so much the courtroom, and you're right about that, no question. I have several times recently, all pro bono for family and friends. It's not my major practice. Been involved in a few of these, and while they're not admissible in evidence, they are very much part of what decides what insurance companies pay or don't pay when there have been accidents. And I think an awful lot of them are resolved. Accidents, the financial piece is resolved that way. That was the source of my concern in offering that.
Thank you, Mr. Goddard. Director Fletcher, or sorry, go ahead, Mr. Sweeney.
I'm sorry, I might make one suggestion, and I don't disagree at all with Mr. Goddard in that regard about the insurance companies. You know, the policy could be that whenever after an accident, a person who is not available to give a statement at the time, their statement will be taken if they contact the police and request one to be taken. So we could go as general as that.
I'm fine with that.
Let me say this. The insurance use the report and they analyze it and they use the opinion of a trained officer that's been trained to investigate accidents from time over and over again. And there are places on the accident report for an officer to make a decision if he see what was at fault. And if he's uncertain, then he makes sure, then he can make it uncertain. But if you look at the concrete evidence from the diagram that you draw from the accident, it's able to tell you whether someone's at fault. But if it's not direct, uncertain, or no witness can give you the exact information that you need, you make sure that you say that you're uncertain about it. And then insurance can go for that, and they'll determine who is more at fault than the next person and go from there.
Thank you, Mr. Holloway. So, Director Fletcher, your hand is up, but I'm not sure if it's... Okay. So I think now we have an amendment to broaden the recommendation. Is that correct? And it was Mr. Sweeney's recommended change. And did that change encompass your edits as well, Mr. Goddard?
Yes, I understood his comment to be to replace what I had recommended, and that is fine with me. I accept that modification.
Okay.
Was that correct, Mr. Sweeney?
Replace it or clarify it or broaden it, but yes.
I think we're at the point where you need to pick one of those.
I think it's all of it, but yes, a new broader.
Perfect.
For whenever anyone is unavailable to give a statement at the scene, who contacts the police requesting to them a statement within a reasonable time, that their statement will be made.
That's fine.
Okay, Mr. Hughes.
Thank you, Chair. I had one other clarifying question. If memory serves, we do not have the specific information in terms of demographic data regarding the officer and the complainant. Is that correct?
That is not information that is identified in this report.
Understood. Is there any way that we might be able, just for purposes of record keeping and data collection, to have any of that information made available? Is there a way that we can request it?
The evidence that was used to come to this decision is available to board members, has been available to board members, though I'm not entirely sure if that in that evidence file that information is contained. Director Fletcher.
So once the is sent over to the chief for review and recommendation, and once that information has come back to us, then we make all of that information available to the public. If the board would like to look at the information that's contained in the file, that information is made available to board members.
That's very helpful, Director Fletcher. I appreciate that. Part of my rationale behind asking that question specifically relates to my concern over issues of equity, access, and representation from the standpoint of individuals who might be impacted differently depending on, their demographic, their background, the area of the city in which they live. We just want to make sure that we're centering the needs and the concerns of those individuals who might otherwise maybe not be listened to or not be heard depending on the certain circumstances involving their interaction with the officer. Just very concerned about making sure that we're respecting those differences, those concerns, and whether or not that might have played a role in whether or not the officer considered it necessary to take the report. But thank you very much for that clarification. I appreciate it.
Thank you.
Thank you, Mr. Hughes. Is there any more discussion on that? If not, if there could be, what's the procedure here? Do we amend the motion to accept, to then make a motion to accept but with edits?
We can change the, or have a motion to amend to address Mr. Sweeney and Mr. Goddard's recommended change to the proposal. I just also didn't know if Mr. Sweeney wanted to address the procedural issues at this point or after a vote. I just wanted to bring that back up.
Thank you, Mr. Pinkley.
I'd be glad to talk about the procedural issues after we have voted, because they're just kind of general.
Thank you, Mr. Sweeney. So since there is a motion on the floor already, does whoever made that motion have to then rescind it, Mr. Pinkley?
I believe, this is Mr. Goddard, I believe my motion with the modification I've accepted needs to be seconded and voted on, and then if whether it carries or not, then we vote on the first motion. But I'm suggesting that to Mr. Pinkley. Is that right?
Or can we take a friendly amendment to the original motion?
You could do that.
Yeah, I think either one of those options would be permissible.
Okay.
I would suggest a friendly amendment to the original so as to approve the recommendation of the executive director modifying the recommendation to the police department to broaden the policy provision to require that in those instances where a person is not available at the scene to give a statement, contacts the police within a reasonable period of time after the accident, requesting to have their statement taken as part of the investigation, be required to take that statement.
Are there any issues with not defining the time period here?
I think that yes, there is, but on the other hand, if you say 2 days, 3 days, 5 days, 7 days, somebody's going to contact the day after that. So, I don't think you can be that specific, but yes, there is an issue.
Okay, so the motion has been made. I should get a second before proceeding with any more discussion, correct?
That's correct.
Is there a second?
Second.
Thank you, Mr. Goddard. Ms. Ross, I saw your hand go up. Not sure if you wanted to say anything.
I'm having a hard time hearing Mr. Sweeney. I'm not sure if he's talking in his mic or I know he has a soft voice, so what he's saying in terms of the amendment is fading in and out. So if somebody with a clearer voice can restate the amendment, please.
I apologize for that, and I'll try to speak closer to my microphone. The amendment would be that the recommended policy is that whenever where an accident has occurred and a person who's involved in it is not available to give a statement at the scene and later requests within a reasonable amount of time to be able to make a statement to amend the report, that their statement will be taken.
Thank you, Mr. Sweeney. And that motion has been seconded. So is there any more focused discussion on that? If there is none, I will take a roll call vote here to approve the proposed resolution report with the stated amendments to the policy recommendation. Mr. Campbell-Gooch.
Aye.
Ms. Davis.
Aye.
Mr. Goddard.
Aye.
Dr. Hildreth.
Aye.
Mr. Holloway.
Aye.
Mr. Hughes. Mr. Hughes. Okay, Dr. Lewis. Not here. Ms. Ross.
Aye.
Mr. Sweeney.
Aye.
Mr. Witzel.
Aye.
And I'll go back to you, Mr. Hughes. I don't know if your microphone is not working. I don't see that you're muted, but we can't hear you. Still can't hear. Do I carry on or do we have to wait for his vote since he is present?
The vote has passed either way, and so I don't know what the technical difficulties.
Got it. Okay, so with that, the motion passes to accept the report, but modify it with the amendment proposed by Mr. Sweeney. As far as procedure, well, I know Mr. Sweeney, you wanted to say something, but do we, that report, once modified, does not need to come back to the board, correct?
Based on the rules, that's correct. It will go as modified to the police chief.
Got it. Okay, Mr. Sweeney?
Yes. At the outset, there was some description of the process that we'll go through and the presumption of correctness. And I just wanted to discuss that a little bit because the way I heard it, it sounded like the only thing that we could consider was the conclusion and the recommendations, and that we didn't have the ability to consider the evidence. And I suggest that if that was how it was explained, then I don't think that's correct, in the sense that it can be presumed correct, but as we go through it, we can revisit the evidence too, and we can decide that the evidence doesn't weigh out the way that the director has presented it. So we can find that it is against the weight of the evidence. It only comes with a presumption, not something that we can't revisit. So since this is our first one, I just thought that it's worth discussion here, so that we can clearly among ourselves discuss and agree on this process.
Thank you, Mr. Sweeney. So it's my understanding that we presume that the evidence presented in this report is correct, given that we judge or for ourselves whether the conclusion reached in this report is the one that should have been reached?
I don't think so. I think what we're presuming is that the conclusion is correct. But if we find it to be against the weight of the evidence that's been presented, that we can then reach another conclusion. So that we are not locked in at that point. And of course, we can also decide that the evidence hasn't been developed far enough and we want further inquiry. So I just don't want us to, without further discussion, be on record of saying that we cannot reevaluate the conclusion of the director if we find it to be against the weight of the evidence and therefore contrary to the presumption.
Thank you, Mr. Sweeney. Mr. Pinkley, do you agree with that?
I think the purpose of the initial introduction was to, I guess, kind of gauge the level to which we wanted to make this an evidentiary hearing versus a presentation of the proposed resolution report. I'm open to the board determining what level they want that to be at, and then I can adjust accordingly.
And I'm not suggesting that it's an evidentiary hearing, but in a court case, when a court receives a matter with a presumption of correctness, that doesn't mean that they can't reweigh the evidence that's presented. They can, and they can reach a different conclusion on it and find that it's contrary to the presumption.
Dr. Hildreth?
Thank you. I offer this with great trepidation in light of my colleague board member who is a former judge. I'm just wondering, Mr. Pinkley, you sent to this board, you resent a PowerPoint outlining the process. And while I have it before me, while I don't see the slides are numbered, I count it as the 10th slide in after the title. And the title of that slide is Board Discussions and Vote. So listed there are 4 options for us. After all discussion is completed, a majority vote is needed to take any of the following actions. And I guess I want to affirm, are these the 4 actions we can take now? And I'm wondering if the latter 2 accommodate Member Sweeney's concerns. So the 4 are: 1, we could accept the report as submitted. The report will then be sent to all agencies identified in the report. 2, accept but modify the report. My sense is that's the vote we just took. 3, reject the report. If the board reaches a different conclusion based on the facts contained in the report, executive director will be instructed to amend and send to appropriate agencies. And 4, return the report for further investigation or analysis. So I'm wondering, my question is, if we presume that the facts that Director Fletcher presented to us are correct, but we come to a different conclusion as to what those facts indicate as to whether or not there was incorrect action, we have the ability to bullet 3, reject the report, and ask the director to amend and send to the appropriate agencies. Is Mr. Pinkley, is that correct, or am I misreading this slide?
In that scenario, the board would have 2 possible options. They have the option to reject the proposed resolution report and reach a different conclusion that is then sent off to the police chief. That's correct. Or they could vote to return the resolution report as a whole back to the staff for additional investigation or analysis.
Okay, so Member Sweeney, does this respond to your concern? And I will take my answer on mute.
Yes, I don't think that there's anything that's been presented to us is contrary to what I'm saying. I don't mean to be saying anything contrary. I think that everything that has been presented to us in the slides and such properly sets forth our authority. But I think the general description that was made at the beginning indicated to me that we had a lesser authority than the slides. And so I just wanted to present as kind of a background consideration as we kind of develop our own process for this, that we focus on the fact that we as the board are the ultimate authority, and that the executive director presents to us. And I'm certain that the vast majority of things that will be presented to us, we won't have any difference as far as the analysis, although we may have differences like here with the conclusion. But there may well be cases where we view the facts that have been presented, which were the basis of the executive director's conclusion, differently. And that's within our power to do. So that the executive director doesn't decide, instead presents a report with a presumption. But we can look through or beyond that presumption in the appropriate cases. So everything that's been presented to us as the slides, I have no problem with. It's just our understanding of our own positions, that's all.
Thank you, Mr. Sweeney. I think my intent with the introduction was to make sure that we were not getting into a discussion about the evidence or the investigation tactics, and rather a discussion about whether the conclusion reached by the evidence was the right one to have been reached. But I will make sure that I work with Mr. Pinkley to clarify that in future introductions.
I do think we can discuss the evidence, and we can discuss whether the evidence points in a different direction.
But the validity of the evidence?
I don't know what you mean by validity. If you're saying, can we question the correctness of what the executive director has said, like that a telephone call occurred on a particular date or a particular witness was interviewed?
Right. If believe that a statement was made.
No.
Something like that.
But on the other hand, if we don't think that that's been thoroughly enough investigated, we can send it back.
Correct.
But if the executive director takes 6 facts and says, and from that fact, those 6 facts, I draw the conclusion X, we could say, no, we think, facts 1, 2, and 3 are stronger than facts 4, 5, and 6, and therefore we don't think that the ultimate factual conclusion is supported by the presumption.
Right. Okay. Ms. Brooks.
Okay. My concern in hearing our conversation is that we get the proposed resolution report, and some individuals were asking about demographics, but be mindful that if we get the proposed resolution report in a timely manner, that we can always, if we have questions, go to the office and review the information that the staff has on hand.
That's correct, Ms. Ross. Thank you for reminding us. Is there any more discussion on that?
Yeah, I do. I think we just need to go ahead and accept the report from the investigation that has been done on this, and just make a comment to the department that they need to look at their policy, and if they need to update their policy on it.
Yes, we have already voted to approve the report in that way. We were just having a discussion for procedures for future proposed resolution reports. Any other discussion here on that? If not, we can move to the policy advisory report. All right. I think Dr. Berlier had a presentation for us here.
All right, thank you. Good afternoon. I'm going to go ahead and share. All right, so following the public hearing on the policy advisory report related to consent decrees, we've made several revisions which were sent to the board last week. And I'm just going to quickly go through the final recommendations that take into account the public comment. So we did receive 3 written comments that were very substantive and helped us shape revisions on the recommendations. We revised recommendations number 1 and number 3, and we added 1 additional recommendation to the report, which is now recommendation number 7. So recommendation number 1, which was revised, now states that MNPD should review policies, procedures, and trainings to ensure consistency between policies in the manual and prohibitions that are covered in training. Actions that are against policy because of training should be explicitly stated as prohibited in the MNPD manual. When appropriate, concrete examples should be provided to ensure clarity. Recommendation 2 is unchanged, and I'll read that. Recommendation 2 states that MNPD should implement promotional and annual in-service supervisor training that focuses on conducting use of force investigations. This training should be in addition to the annual in-service training provided to all sworn officers. Recommended training topics include conducting use of force investigations, strategies for effectively directing officers to minimize use of force and to intervene when effectively to prevent or stop unreasonable force, incident management, and supporting officers who report unreasonable or unreported force, or who are retaliated against for using only reasonable force or attempting to prevent unreasonable force. Recommendation 3 was revised. Recommendation 3 is related to crisis intervention teams. We received comments that helped us strengthen this. So recommendation 3 now reads, MNPD should create a crisis intervention team comprised of specially trained officers for response to crisis situations involving mental health issues, including drug addiction. CIT officers should work closely with civilian mental health professionals and, when possible, should be accompanied by a mental health professional co-responder when responding to crisis-related calls for service. The MNPD manual should comprehensively outline policies, procedures, and roles related to crisis intervention program, including trauma-informed, situation-based guidance for officers responding to the scene of a crisis. Since a CIT will require a long-term implementation plan, MNPD should aim to create a budget-neutral plan for developing the program. If additional resources are needed, those should be detailed in a request to Metro Council for the fiscal year 2022 budget. Recommendation 4 is unchanged. That recommendation is that MNPD should categorize all use of force above unresisted handcuffing into 3 levels that will guide the reporting and investigation of the use of force. Recommendation number 5 is that a force investigation team should be created as a branch of OPA to investigate criminal and administrative aspects of uses of force resulting in serious injury, all firearm discharges, misapplications of force, and other serious uses of force as defined by the department. They should also investigate fatal uses of force for violations of administrative standards parallel to the TBI criminal investigation. The unit should receive specialized training in conducting use of force investigations into serious uses of force. Recommendation 6 is unchanged, and that recommendation is that MMPD should track and analyze use of force data and create an annual use of force report that is available to the public. The analysis in this report should examine the relative frequency and type of force used by officers against individuals in specific demographic categories, examine MMPD's use of force over time, and identify and address any trends that may warrant changes to policy, procedure, training, tactics, equipment, or practice. And recommendation number 7 is a new recommendation. And that recommendation is that MMPD should publish an interactive dashboard of monthly or quarterly use of force statistics, including, but not limited to, the race, ethnicity, age, and gender of subjects, the type of force applied, the type of resistance from the subject, injuries sustained by officers and subjects, the geographic area where the use of force occurred, and the call types where force was applied. So I'm happy to take any questions on any of these recommendations, and I'm looking forward to the discussion of the board related to these recommendations.
Thank you, Dr. Berlier. Are there any questions from the board here? Mr. Campbell-Gooch.
I think these are incredibly dope recommendations. So I wanted to commend the staff first, but I did notice that one of the recommendations was budget neutral. I want to say this like recommendation like 3 or 4. My question to Dr. Berlier is, are most of these recommendations, in your opinion, are most of these recommendations something that can be administered budget neutral?
Many of these recommendations could be budget neutral. The ones that may not be include force investigation teams, since resources will have to be deployed into force investigation teams, which will require dedicated officers, as well as training resources. The CIT recommendation number 3, we added a statement around budget neutral plan, since there is grant funding available in many cases, as well as there are cost savings associated with crisis intervention teams that have been found in various cities, and the Department of Public Health has had so far with the implementation of crisis responders, and in Nashville has found has found that it has saved time and money for the police department. So I think there may be some instances where there may need to be some budget requests. However, I believe that the majority of these recommendations can be done with existing resources and shifting priorities into making data more transparent, to making reports more public, to posting information online that already exists, as well as to review policies, where recommendation number 1 is stating that policies should be reviewed to ensure consistency. That doesn't require additional resources.
Thank you for that. And then I just had, thank you for providing that clarity. And then I just have one more question about recommendation 5, or like, and I think this might be just like a general overall question too, but if you can talk about why the use of the force investigation team that's in this recommendation should be created from OPA, as a branch of OPA, and then also curious to see how MNCO can fit in any of these as well.
Absolutely, I think that's a great question. And this is, we base this off of the most common structure that was recommended in consent decrees. And there are several cities where the force investigation team is separate from their internal affairs function. However, the majority of the consent decrees recommend that the force investigation team be independent, but housed within the same branch as internal affairs, which is OPA. The force investigation team should have its own leadership and be relatively independent from OPA, since they are separate investigation streams. So the OPA would be covering misconduct investigations, whereas the force investigation team would be investigating all serious uses of force. And those are, according to the research that has been done on force investigation teams and a lot of the writing, those are separate functions that are both very specialized. And so having that team have independence from OPA, when they do find misconduct, can refer that case over to misconduct investigators. But having that structure allows for the internal review functions of the police department to be to some degree combined in order to save resources, where you have one director that can oversee multiple aspects of internal investigation, one into misconduct, as well as the other into force investigations, even while those are both independent departments.
Well, and then this is just my last question, and you know, I feel like I'm taking up too much space. But so you mentioned something about it being internal. What does this look like externally, like outward facing, especially when it comes to how the public can interact with this type of data output? And then second, what would be the role and the ideal role for MNCO with these recommendations?
Yes, I missed the MNCO portion. And I think a good example of how a force investigation team and the civilian oversight entity interact is New Orleans. New Orleans, the force investigation team, whenever the force investigation team is called to an incident of serious use of force, an investigator from the independent police monitor also is called, right? So the independent police monitor is able to have a close relationship with the sergeant that leads the force investigation team. And whenever that team goes to a incident, there's also an investigator from the oversight agency. And so this could actually be a strength for MNCO, with being able to build strong relationships with a single part of the police force that will be called to every single incident involved in serious uses of force, which are the ones that MNCO will also be investigated. And so I think having this structure really will help streamline some of those investigations, strengthen the relationship between MNCO and MMPD related to force reviews, and also help with having consistent data, right? So in other cities, the force investigation team is responsible for assigning force tracking numbers, with making sure that data is complete and that supervisor investigations are complete. So they can take a number of functions that will make the process more streamlined and more transparent. And since you will then have a group of officers focused entirely on investigating and tracking uses of force within the department, hopefully that will create a structure that will be more effective at investigating these serious use of force incidents.
Thank you, Dr. Berlier. Are there any more questions about the policy advisory report? If there are none, we can either vote to approve the report with all of its recommendations, or we can do each recommendation on its own. So if anyone wants to move to approve the report or approve a single recommendation, we can do that now.
Chair, so moved.
What was that? Sorry, I couldn't hear that.
Oh, I'm sorry, I'm breaking up on this end. Yes, I'd like to move that the report be approved in its completion.
It's the motion to approve the report with all of the recommendations, correct?
That is correct, Chair.
Okay, thank you. Is there a second?
Second.
Thank you, Mr. Goddard. Any focused discussion here? If not, I will take a roll call vote. Mr. Campbell-Gooch?
Aye.
Ms. Davis?
Aye.
Mr. Goddard?
Aye.
Dr. Hildreth?
Aye.
Mr. Holloway?
Aye.
Mr. Hughes?
Aye.
Dr. Lewis? She's here with us. Ms. Ross?
Aye.
Mr. Sweeney?
Aye.
And Mr. Witzel?
Aye.
And I vote aye as well. So we will also send these recommendations to the chief as well. Thank you very much, Dr. Berlier, Ms. Orozco, for your work here on this important report. We are now on new business and announcements. If there are none, then I think we can adjourn here if there's a motion to do that.
Chair, as a point of personal privilege, I just wanted to give one brief announcement. Just wanted to encourage everyone who has not yet voted early to make sure that they do that before the deadline, which is October 29th. And if they do not vote early, just to encourage those who have a plan to vote to do so on November 3rd.
Thank you, Mr. Hughes. Very important. There are long early voting lines. So Mr. Hughes has a point. You should make a plan to vote so we don't get caught up in the last minute in a long line. Any other new business or announcements? If not, I will take a motion to adjourn.
So moved.
Thank you, Mr. Goddard. Is there a second?
Second.
Thank you, Mr. Hughes. Take a roll call vote. Mr. Campbell-Gooch?
Aye.
Ms. Davis?
Aye.
Mr. Goddard?
Aye.
Dr. Hildreth?
Aye.
Mr. Holloway?
Aye.
Mr. Hughes? Mr. Hughes? Okay. Dr. Lewis, I don't believe is with us. Ms. Ross?
Aye.
Mr. Sweeney?
Aye.
Mr. Witzel?
Aye.
I vote aye as well. Thank you very much, everyone. We'll see you or hear from you next week.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.